application and appeal in the matter of Haque and the Hussain and others.
May it please you, my lords, in this matter I appear on behalf of the appellants, the first, fifth, sixth and seventh defendants. Mr. Nazar Mohammed appears on behalf of the respondent, the claimant, known for short as MQMP, Mutahida Qawmi Movement, Pakistan. The defendants would say that MQMP has been in existence since September 2016. The respondent claimant's case is that MQMP has been in existence since 1984 and is simply a change of name from Mutahida Qawmi Movement. There have been claims brought by MQMP through their representative, Mr. Haque, on the basis that the first to sixth defendants were trustees, express trustees, of 6 properties in London. In addition, there are claims against the fifth and sixth defendant that they were knowing assisters or constructive trustees, and against the seventh defendant, Euro Property Developments Limited, on the basis that it was in knowing receipt of trust funds. The defendants who I represent on this appeal have been known as either the relevant defendants or the active defendants. The other defendants have played no substantial part in these proceedings. That is defendant number 2, Iqbal Hussain, who originally instructed my instructing solicitors and were party to the defence which was served in November 2020, but then withdrew his instructions and has played no further part in the proceedings. He is the brother of Mr. Altaf Hussain, the first defendant. Defendants 3 and 4, again, expressly named as trustees. Defendant number 4, no, I should say that they, at the time that this litigation started, the claimants sought to make terms with defendants 3 and 4 and prepared a consent order for that purpose. But I think that consent order has never been approved by the court. But nevertheless, defendant 3, although he has legal representation, has not participated at trial in any way, and defendant number 4 is deceased.
Neither of them participated in the defence.
Neither of those participated in the defence, that's correct.
So they've taken no active role in the proceedings.
They've taken no active role in the proceedings, although defendant number 3 has solicitors who are interested to know what is going on, but they never were represented at the trial in front of Judge Jones.
No attempt has been made to substitute anybody to represent the estate of the fourth defendant.
No, although there was an order that should happen in October 2021, but it never did, and that's at page 124 of supplemental bundle 1.
Thank you.
There was a 2-stage trial of the issues in this case, ordered by Master Clerk in October 2021, and that's to be found at the page I've just mentioned. So that is S1, supplemental 1, S1, page 124.
Yes.
Paragraph 3 of,
Yes.
of that order was the order that I just mentioned, that the claimant shall apply to either join the personal representatives or to the order appointing a person. If that, I know nothing about any such application if it was ever made. But the important paragraph for these purposes is the split trial. The trial of the claim shall be split into 2 stages. Stage 1 shall determine the constitutional issues in the action, and then there are specific paragraphs of the particulars of claim and defence mentioned. And stage 2 shall determine the breach of trust issues in the action, whether the defendants have acted in breach of trust, and what financial or other relief should be granted to the claimant as a result. Stage 1 went for trial in front of Judge Jones, sitting as a High Court judge, over 7 days, starting in November 2022 and ending in January 2023. He concluded when he gave judgment, and his order is at the core, Arnold, page 58. He concluded that the properties and 53 Brookfield Avenue, the only reason why that's separate from the properties is 53 Brookfield Avenue had been sold before the litigation started, and so it was a question as to what should happen about the proceeds of sale, not the actual property itself. The judge said that, or declared that the properties and 53 Brookfield Avenue was beneficially owned absolutely by the membership from time to time and the political party registered as NQMP, and this is the significant part, an unincorporated association formerly called and registered as Mutahida Kwame Movement, MQM, and for whom the claimant is the duly appointed representative for the purposes of this action. He reached that conclusion, as you'll be aware, my lords, without deciding the constitutional issues which formed stage 1 of the trial. It was the judge's view that the constitutional issues were in an unsatisfactory state, that he could decide the litigation without dealing with the constitutional issues, and that's what he proceeded to do.
When you say an unsatisfactory state, evidentially or?
I think he thought that the parties had not sufficiently recognised the issues in the constitutional issues, various aspects of it, and so he abstained from deciding it. But he also took the view that the constitutional issues weren't a defence for these defendants in any event. And it is what we would submit with the surprising result of that judgment that we seek to appeal today. We obtained permission from my Lord Justice Arnold that was on the papers in August 2023, and here we are.
It might be worth at this juncture raising a couple of questions for you to be thinking about, and you're not necessarily answering now. Question 1, if we allow the appeal on ground 1, should we also determine grounds 2 and 3 or not? And if not, what happens to them? maybe we should determine those grounds in any event, but I raised the question. Secondly, if we allow the appeal on ground one and remit the matter to the High Court for the constitutional issues to be determined, what should we do about the judge's findings of fact? For example, with regard to the his finding that the April 2016 Constitution was adopted. So one of the questions that will arise will be the extent to which there should be, as it were, a direction with regard to what one might call retained facts, or whether everything should be at large again. And the reason why I raise question 2, of course, is that it has quite significant costs implications. Because if everything is at large again, then everything has to be retried. Whereas if one can remit the constitutional issues on the basis of some retained facts, then that reduces the scope of the retrial. So, as I say, I'm not expecting answers to these questions here and now, but I thought it was worth flagging them up.
Thank you. If I can just give my instinctive answer, which I suspect I will then reverse later on, but my instinctive answer to those questions are these. Under the first question, your lordship has raised a point that the judge has gone some way into the constitutional issues. For example, he has decided ground 3 adverse to us, so that's an issue of construction, and clearly we've felt it necessary to appeal that. He's also decided, and this is related to your second question, what do we do about findings of fact? We are not appealing his finding of fact that the April 26 Constitution was the one in place as at August, September.
You said April 26, you mean April 2016?
I certainly do mean April 2016, I beg your pardon, yes. We don't like his conclusion, and indeed much of the trial was spent in addressing all the reasons before the judge why he could safely conclude that there was a constitution in place as from October 2015, but we lost on that. And we're not appealing that for all the factual background reasons that you would understand. However, the judge, in the course of his judgment, did offer a further hearing on the constitutional issues, and that, I think, was in his mind to be a limited hearing, and what we seek to remit is a similarly limited hearing. The reason why we couldn't say to the judge it is a good idea to have a further hearing on the constitutional issues is that the way he had approached things in his judgment made such a further hearing pointless, because he had already decided that MQMP was the same as MQM.
Yeah, well, we understand why you're here. But as I say, it's a question of working out the consequences if, and I stress, if we're with you on ground 1.
Yes. What I was proposing to do, my lords, is to address aspects of the background, take you to the Constitution, take you to a very few important documents which are relevant to the constitutional issue, then give you an overview of the judgment, And after that, it would be necessary to look at the pleadings, because much of our complaints in this appeal relate to the fact that the route that the judge took was not a pleaded route. And then I will address the 4 grounds of appeal in the order in which they come. The first ground of appeal has 2 branches to it, 1A and 1B. That's how I get up to 4. They're called 1A, 1B, 2 and 3. Before I start, I should mention that there are 2 outstanding applications for permission. One is for permission to refer to unagreed bundles, but I'm pleased to say that can be shortcut because the bundles have now been agreed, so there's no point on that. The other is that on the 12th of April, I served a supplemental skeleton. The main purpose of that supplemental skeleton was to address what Mr. Mohammed has described as preliminary issues in the appeal. This is not something on which we had had the opportunity to address in any skeleton argument served so far. So that's why we produced it, in order that you, the court, have the material at your fingertips.
So you technically need permission for that?
I do need permission for that, and we made an application for permission under a covering letter that came with the skeleton.
Right.
But I think Mr. Mohammed has some observations on that. It may go so far as to
but
resist.
before we hear, I mean, let's think about the point you make that the so-called preliminary issues are properly the subject of a respondent's notice, and you make the point that there is no respondent's notice. But if Mr. Mohammed were to ask us to treat his skeleton argument, raising the preliminary issues as a respondent's notice, would you have any objection to it if you were then allowed to rely upon your supplementary skeleton?
Well, my objection would then fall back on the things that would have happened had these points been raised earlier on.
Well, that's a question of the merits of them.
No, it's a question as to whether they should be permitted to be argued at all. So,
Well, not having been raised below.
not having
Yeah,
been
so
raised.
that's
below.
a Singh and Daz point. Yeah.
Exactly. That's
But that
where it
point
would fall in.
would have arisen even if there had been a regular respondent's notice.
Yeah, yes, it would have done.
Yeah.
It is also true to say that if you have a pleading, that defines the issues better than if you have things, a number of points in a skeleton argument. So
you want your supplementary skeleton admitted to enable you to respond to the preliminary points as and when you need to.
That's it. That's it. And how the court will wish to treat these preliminary points, I will leave to your lordships. But
Yes.
but I want to be able to refer to it. And there are 1 or 2 extra points that it raises at the outset.
Yeah.
But they wouldn't require a skeleton argument to be
Yeah.
raised. But these
Thank you.
preliminary
Yes.
points do.
Should we hear briefly from Mr. Mohammed? Mr. Mohammed.
My lords, the preliminary points, and I note the CDAS issue. Those preliminary points are pure points of law in my submission, and therefore a respondent notice was not and is not required.
Sorry, I don't understand that.
Well,
If you seek to affirm a judge's decision on alternative or additional grounds, then whether they be factual or legal, you require a respondent's notice.
my lord, the points that I make in the preliminary are points that arise from the judgment itself, and they do not differ. They may amplify the issues that arise in the judgment, but in any event, my lord, the Singh Das point that you've alluded to, that could enable the respondent to rely on those points. With Singh Das, as my lord, you'd be aware, the three factors that are required.
Well, hold on a second. At the moment, we're just dealing with the application made on behalf of the appellant that his additional skeleton, supplementary appeal skeleton, be admitted. So do you want to do, so if we are to consider your preliminary issues, then it seemed to me we have to allow Mr. Slade to adduce a skeleton argument dealing with them.
My lord, if the court is minded to treat it that way, then I will sit down and accept the court's view on that. I don't need to be addressing you on the Singh Das issue at this stage or at all. So in that case, my lord, we will proceed on the basis that if you give permission for Mr. Slade to rely on his supplementary, and then you also will be allowing me to keep my preliminary points.
Yeah, I think you may need to deal with the Singh Das issue, but just not now. That's what I'm saying.
Yes, my lord.
So should we just, yeah, all right. So what it I think would seem to us is that you raised those points in your reply, and then rather than Mr. Slade dealing with them in advance, Mr. Slade deals with them in his response.
Yes, my lord, that is the situation.
Yes, so we give you permission to adduce your supplementary skeleton.
Thank you, my lord.
And all the arguments in respect of the validity or otherwise the preliminary issues you can deal with in due course.
Yes. Mujahida Kwame movement means United National Movement. It's a political party that was founded by Mr. Altaf Hussain, the first defendant in Pakistan in 1984. And its purpose is to give voice and recognition to the muhajirs, the migrants who left India for Pakistan at the time of partition, and to their descendants. Mr. Altaf Hussain has been the dominant figure in MQM since the outset. He is known as MQM's ideologue leader. He's always enjoyed a lot of public support in Pakistan, and he commands intense respect from his followers. Although he was the founder and ideologue leader, he was never an office bearer of MQM under its constitutions. Mr. Altaf Hussain was the target of a grenade attack in December 1991 and has been living in exile, self-imposed, in London since January 1992. MQM operates under written constitutions. They all provided for a central coordinating committee, which is sometimes known as the Rabta Committee, and under the wording of the constitutions, the Rabta Committee was the highest policy and decision-making organ of MQM. Nevertheless, Mr. Altaf Hussain has always been the dominant figure in MQM, and the Rabta Committee accords his views great deference. The current dispute arises because in August 2016, certain people within MQM decided to take a course of action in order to oust Mr. Altaf Hussain and his London followers, and in fact any followers outside of Pakistan. And the background was that on the 22nd of August 2016, speaking from London, Mr. Altaf Hussain made a highly charged and emotional speech against human rights violations by the Pakistan military authorities and the intelligence services in Pakistan. He was addressing workers on hunger strike in the Karachi Press Club, and this caused a backlash from the Pakistan military, and civil disturbance in Pakistan. There were clashes between heavily armed police and paramilitary rangers on the one hand, and protesters on the other hand. Mr. Altaf Hussein's speech was very controversial. It even resulted in him being charged in England under the Terrorism Act, for which he faced trial at the Kingston Crown Court and was acquitted in January 2022. At trial, it was not considered necessary or appropriate to the issues to review the content of the controversial speech of 22nd of August. But the defendant's case was that as a result of that speech, Dr. Farouk Sattar, who was the senior deputy convener of MQM, saw an opportunity to increase his own power, and he invited Mr. Altaf Hussain to step back temporarily from his dominant position within MQM in order to calm the situation in Pakistan. Now, this was a matter in dispute and something on which the judge made no finding. Mr. Hussain stepped back by an announcement made on the 23rd of August 2016, and then, despite all that Mr. Hussain had done for MQM, Dr. Sattar and his associates cut loose from Mr. Hussain and expelled him without any attempt to ask Mr. Hussain to explain himself. Mr. Hussain's evidence at trial was that they did this under pressure from the military authorities and ISI, the Pakistan Intelligence Services. Dr. Farouk's associates also barred and later expelled London-affiliated members of the Rabta Committee. This was a blatant injustice to Mr. Hussain and others. It was also, importantly, we submit, a breach of the requirements of MQM's constitution.
It's not, wasn't disputed that there were London members of the Rabta Committee.
No. In fact, it is suggested that there were 8 of them. That's in one of the claimant's own documents, but the precise number may be open for debate or was not determined by the judge. MQMP is now viewed by Mr. Hussain and his followers as a separate association, the result of an attempt by the military establishment to pressurize senior figures within MQM, to divert MQM support, and to weaken MQM and Mr. Altaf Hussain. The actions of Dr. Sattar to rig the Rabta Committee, to exclude Mr. Altaf Hussain's supporters from the Rabta Committee, and to expunge Mr. Hussein's name from the Constitution, amounted, in the view of the defendants, to a betrayal of MQM's interest, and instead advanced the interests of the military establishment in promoting what was labelled the minus Altaf or -1 formula. That is a political party which did not involve Mr. Altaf Hussain. MQMP's attempt now to take possession of properties put into trust long before MQMP even existed is illegitimate and viewed by these defendants with outrage. But stepping away from the outrage and back into the law, it was common ground between the parties at trial that the burden lay on the claimant to explain why MQMP was a legitimate development of MQM consistent with the relevant constitution of MQM. The constitution, which the judge held in his judgment to be applicable in August 2016, is that at core bundle page 182. The actual text starts at page 183, and it has an odd feature which we'll come to, which explains why we have an inserted page at page 182. You can see at the top of page 183, this is the Constitution of Mutahida Kwame Movement. It's dated 2002, but there's manuscript which says it's something to do with the 23rd of April 2016, and that is thought to be the date at which this constitution was lodged with the Election Commission of Pakistan. This particular document did not emerge at the start of the case. It didn't emerge until the claimant gave responses to requests for further information in November 2021, so over a year after the case had started. Article 1 names the movement as the Mutahida Kwame Movement. Article 3D on page 184 defines the committee, and that's the same as the Rabta Committee. Article 9A and 9B are key to the constitutional issues. The powers and functions of the Central Coordination Committee. A, the committee shall be the highest policy and decision-making organ of the movement. Its decisions shall be binding on all party organs and members. Ordinary decisions shall be made by a simple majority of members present in a scheduled meeting, while in the important and major policy decision, 2/3 majority of the committee shall be required. And there's a dispute under ground 3 of the appeal as to how that requirement should be read. Article 9B is very difficult to read because it had some highlighting, don't know why it has highlighting, but it had highlighting that virtually blocked out the text. But there's no doubt what it says, because we can tell from other documents, and the judge made a finding about it, and it says what we see at page 182. The Central Coordination Committee shall seek guidance from Mr. Altaf Hussain, being the founder and ideologue, on the major issues for his ratification.
There was some issue at trial that this wording varies slightly from a previous iteration of 9B, with no obvious statement that it had been amended. How did the judge resolve all that?
He didn't conclude. He thought it might have been a mistake, although he made no finding to that effect. But he did conclude, and this is at paragraph 97 of his judgment, he did conclude that this wording that we have here at page 182 was the wording in force.
And that's the operative wording,
That's the operative wording.
and you don't appeal that? That's,
No.
no.
That's at page, core bundle page 86, paragraph 97 of his judgment. Article 10, no rules and regulations or any part of this constitution shall be rescinded or amended except by a 2/3 vote of the committee. So that is a repeat of, or not quite a repeat, but it refers to the same 2/3 and it refers to the committee as we see under 9A. And then go to Article 13, please. All party officers shall be filled by elections of the members after every 4 years. And B, until reelections are held, the committee shall fill existing vacant offices by a decision of at least 2/3 majority. And then I draw your attention to Article 4A. Every office holder shall hold his office for 4 years from date of notification.
Sorry, which one?
Article 14A, I misspoke.
14A.
Put it in there on page 189. Every office holder shall hold his office for 4 years from date of notification. And that's mentioned because of the facts. There were elections, MQM elections, in April 2016, and it should have followed that the following elections would take place in April 2020. But in fact, there were elections that followed fairly smartly after Dr. Farouk Sattar got purported amendments to this constitution through. And so there were further elections in October and November of 2016.
Where's the membership of the committee dealt with? Excuse me.
The I think it comes under the organisational and management under Article 6.
So it's A, is it?
Yes,
So there's a convener.
there's a convener, there's a senior deputy convener,
Yes.
there's some deputy conveners, and then there's some members.
And there have to be at least 15 other committee members, or I say other, let's assume,
Some,
and a maximum as may be required.
So there's a minimum membership of 18.
we know that as at when the election took place in April of 2016 for MQM, there were 22.
Yeah, well, there doesn't seem to be any maximum membership.
No.
But there's a minimum of 18.
Yeah.
So 22 members, sorry, so can you say that again?
In April 2016, there were 22 members
Right.
elected.
Including the convener and the others?
Yes.
Okay.
And Article 17, this is referred to because of there's an emphasis laid on the point that constitutional amendments, is said by the claimant, were not challenged ever under Article 17. If a party member has any complaint against any office bearer, that seems to be repeated, he or she will submit his or her complaint in writing to the committee. The committee thereupon shall constitute a subcommittee to investigate, undertake a proper hearing, and forward its recommendations to the committee for the final decision. In either case, the aggrieved member, if he/she so chooses, has a right of appeal to the entire committee, whose decision with a 2/3 majority on this matter shall be final. Those are the provisions of the Constitution that may come up. And now I'd like please to take you to one or two documents in relation to the constitutional issues.
Just before you leave the Constitution, you showed us Article 14A.
Yes.
About every office holder will hold office for 4 years. Is office holder a defined term? Is there any agreement as to what it means? Is there any argument as to what it means?
I'll need to take instructions on that, my lord. I don't know the answer. I know that Article 7 deals with the duties and functions of the office bearers. And it may be that the office bearers are the same as office holders, but they include under Article 7 members. That would seem to be a very large number of office bearers or office holders. So I'm not sure.
Is it? I think the personal question is: does it include members of the Rabat Committee? And I apprehend your submission, in light of what you just said, is that 7D members would at least comprise members of the committee.
That's right.
Don't worry now, Mr. Slade, if it's not a simple
Yes,
question. At some point.
I will investigate. Sorry, I don't. I'm turning now to volume S1 to just look at some documents in relation to the constitutional issues. We start, please, at page 20. This is a note of proceedings of a meeting under the presidentship of Dr. Farouk Sattar and held on his roof on the 24th of August.
I'm sorry to take you back to Constitution. I didn't see reference to President as one of the officers that you showed us in the Constitution.
No, I think that there is no office of President. It may be it may be a way of saying that he presided, or it may be a way of indicating that he has a holding role at this time.
It's also referred to as party leader. Is that senior convener of the Rabat Committee? That seemed to be the most senior post you showed us.
The way that works, my lord, is under Article 7 of the Constitution. The convener is the party leader of NQM.
And Dr. Sattar was the senior convener?
No, he wasn't. He was a senior deputy convener.
Oh,
He wasn't the convener. The convener was a Mr. Nusrat, who was in London. So there was obviously some consideration about how it could be that the senior deputy convener could preside, because he is allowed to preside in the absence of the convener under Article 7B.
Sorry, you told us who the convener was. That was
The
Mr.
convener was a
Nusrat,
Mr. Nadim Nusrat.
and he's in London.
He was in London at the time. Yeah.
Thank you.
Now, I don't need to refer you to all paragraphs, but he comes towards the end of the bottom paragraph on page 20. The participants, therefore, resolve to take certain important measures, as suggested, not only to save the parties and the millions of its members and supporters from falling into a state of chaos, disintegration and disillusionment, but also to counteract and mitigate the adverse effects of the pronouncements made on the 22nd of August 2016. And that is a reference to Mr. Al-Hussein's speech. Measures suggested that the party shall be run from Pakistan, with its headquarters at Karachi. So this is envisaging that the party shall not operate out of other places except Pakistan. That's where it'll be run. Next provision. A committee may be formed forthwith comprising members of CEC Rabta Committee present in Pakistan. So it does not include those who are outside Pakistan. And then it makes reference to some old veterans of the party. So it's co-opting people who aren't members of the Rabta Committee at this time at all. Then recommendation number 1, recommend to amend the constitution of the party under Article 10. That's the one which refers to changing the constitution, and under the accepted doctrine of necessity as early as possible. But it's not explicit, this recommendation 1, what changes are going to be made exactly. That becomes clear later in the week. Copy of the Constitution duly amended and adopted by the party will be forwarded to the Election Commission on the heels of the Constitution that was forwarded to the Election Commission on the 23rd of April. So there's going to be a new copy of the Constitution sent to the Election Commission to take the place of the one that we've just looked at. Fresh intra-party elections shall be held forthwith in the light of the amended Constitution. So that's not in conformity on the face of it with the 4-year period. It was also resolved to induct a few veterans of the party into the CEC Rabta Committee, who will continue only till the party elections and elections of office bearers are held. So there's temporary co-option of other people. And then a provision that the amendments in the Constitution shall be ratified by a 2/3 majority of the Rabta Committee after the above elections. Till the Constitution is amended and the elections of the parties and office bearers are held, Dr. Sattar would continue to hold the fort. That's a note of something that happened on the 24th of August, but it already holds within it one of the offensive aspects to the amendments that were proposed, which is that you can cut certain people out of the Rabta Committee and put other people in, no doubt those who are supporters of Dr. Sattar and will do what he wants.
Do we have the attached documents?
No. No, and I can't remember whether we did in the trial bundle. I'm afraid we have filtered out certain key documents for the purposes of this appeal, but may I remind myself and see. The next page, page 22. This is a newspaper report which came out on the 27th of August 2016, and this is the Prime Minister's spokesperson, Dr. Hussain Malik, quoted as saying that MQM would be allowed to continue their political activities in Pakistan. However, they will have to amend their constitution and disassociate from their chief. And this is relied on by the defendants as evidence of the pressure that Dr. Sattar was under from the government. And in Pakistan, it is difficult to distinguish between the government and the military establishment. This is evidence of the pressure that there was to oust Mr. Altaf Hussain from MQM.
This is a very minor point, but MQM is spelt in the headline. Poorly is spelt QAU, whereas elsewhere it's spelt QUA, which is correct?
I think it's QUA. I may need to ask somebody who is more proficient in Urdu, which I certainly am not, as to how it should exactly be.
Yes, it's not the most important.
And then a very important document, page 27. This is a note of the meeting that took place on the 31st of August. An emergent meeting of MQM's Central Coordination Committee. So it purports to be an emergent meeting, I think an emergency meeting of the RABTA committee. And there's the agenda.
I'm sorry, which page are we?
Page 27 of S1. Now we can see some more detail. Well, it starts at A on page 27. This purports to authorise or to propose the induction of 4 people into the committee under Article 13B of the Constitution. Article 13B is a provision that requires a 2/3 majority. So if you can't get a 2/3 majority, you can't induce 4 extra people. That would be the defendant's case on the constitutionality of that. Ratification, I need to refer to B. C is important, omission of Article 9B in MQM's constitution. That is the mandatory requirement to seek guidance from Mr. Altaf Hussain. Substitution of Article 7B, and we see the point of that. That is to enable the senior deputy convener to preside over all the meetings of the committee and to act as party leader in the absence of the convener. You can see that from paragraph 11. That's what's proposed, paragraph 11 of this note. And then on page 28, there are 20 names of RABTA said to be members of the committee, 20 names. At the bottom of page 28, 3 people could not attend as they were in jail. And then go to 5 on page 29, 4 people are added. And then we can see what they're seeking to do under paragraph 9 on page 30. They're trying to take out paragraph 9B of the Constitution, and then the changes to Article 7 that I've just mentioned. And the new 7B is designed to ease the way for Dr. Sattar to preside over the meetings and to act as party leader in the absence of Mr. Nusrat from Pakistan. And then at 13, it's unanimously agreed to convey the instant resolution to the Election Commission of Pakistan forthwith, so they're going to do that straight away. Okay, note that another meeting was held on the 1st of September, and at 15, most of the members of the Central Executive Council was also present. That's not the same as the Central Coordination Council, the RABTA committee. Then you get the names of the signatories, attendance of the participants, and there are 20 names, which don't include the 4 who have apparently been co-opted. They are the same 20 names that you see on page 28 earlier in the document. And it was our submission before the judge, and if there was if the matter was remitted, we would continue to submit that there wasn't the requisite majority attending the meeting.
How many do you say members of the Central Coordination Committee that were there at the time.
It was, if you look at elected members, there were 22,
Yes.
but 8 affiliated to London were not present. And 3 that we see at the bottom of page 28, they were not present either. And so with 11 people being absent, you can't get a 2/3 majority out of the 20 people who say they were there. That's the simple way of putting the case, but there is a more complicated development, which is that if you include people who were co-opted after April, after the April elections, if you include them, then you have to look at the evidence to see what number that could be. We did give submissions to the judge on this, both parties gave submissions to the judge on this, but we say you still don't get to a 2/3 majority. In fact, you get further away from it.
Sorry, the names listed on 28, excluding the 3 absent, is 20.
Yes.
But you say there were only 22 elected members of the committee, of whom 8 were in London.
In order to get to this 20, I think you have to include people who have been co-opted since.
Oh, I see.
So they're
Okay.
not all.
That
elected
is not the co-op. I understand. There were some co-opted other than the 4
Yes,
who were
yes,
co-opted.
there were. Yes, there were.
I've got
yes,
it.
Yes, exactly.
Okay.
Yes, there were. Yeah. Now, after these amendments were publicised, there was immediate protest from supporters of Mr. Altaf Hussain, and we can see those on page 36. This is from a Mr. Wase Jalil, who says, "We will not accept the -1 formula on Altaf Hussain. Altaf Hussain is MQM and MQM is Altaf Hussain. We will not accept any resolution in NA." I think that means National Assembly. So that's a rejection of what has happened. And then Mr. Aziz Abadi on the next page, page 37, again, very promptly after this news comes out about these changes, "We will never accept the changes in basics of our beloved MQM. No MQM without Altaf Hussain." And then on the next page, there's this is page 38, Mr. Qasim Ali, who protests, and although his protest is in Urdu, it was translated at page 163 of this volume in his witness statement, and he says that these tweets roughly translate as: "The Rabta Committee in Pakistan is working on a -1 formula. MQM is nothing without Altaf Hussain. Righteous workers and supporters of the MQM were not ready to accept the -1 formula before, and they're not ready in the future." And then we see on page 39 a picture of Mr. Nadim Nusrat, the convener. This news item was posted on the 21st of September 2016, and we can see that from what's said just under the photograph. If you go, it's quite difficult to read, and I'm sorry, but if you go to the 4th paragraph, convener Nadim Nusrat emphasised that Mr. Altaf Hussain had relinquished all his powers to the Rabta Committee in the larger interest, but afterwards his discretionary powers were taken away from him in an autocratic and dictatorial manner, and his name removed from the constitution of the party. He added that those discretionary powers were not handed over to him by a few persons, but by thousands and thousands of workers, and therefore few persons can't take away the powers, and changes in the Constitution can only be made by a full quorum of the Coordination Committee in the presence of workers. Nadim Nusrat stressed that paradoxically yesterday even the convener was removed, that's him, and today a resolution against Altaf Hussain has been tabled, an action demanded under Article 6 of the Constitution of Pakistan against him. That is an attempt to bring treason proceedings against Mr. Altaf Hussain. He added the steps have been taken by a few members under the pretext of saving the party, which is not in the interest of the party and the Moylan nation in any way, spreading confusion and despondency amongst the workers and people throughout the country every passing day. Under the circumstances, he said, that the Central Coordination Committee, organisational structure, and all the wings of the MQM have been dissolved, and the Central Coordination Committee and all the wings would be formed afresh, and he's being empowered by Qaid Terak, Mr. Altaf Hussain, I think that means a distinguished leader, to make such changes. He said that Mr. Altaf Hussain has asked the workers and supporters to abide by these decisions and maintain unity in the rank and file. So those are certain key, they're by no means all the documents, but there are certain key documents which go to the constitutional issue, and the ones that follow on from the amendments made on the 31st of August, they are there to show that there was protest made about these changes at the time, and that is relevant. I will be submitting when we come to look at the terms of the judge's judgment. It can't be said that the decision taken on the 31st of August was too minor for the court to pay any attention to. That is the rigging of the Rabta committee and the exclusion of Mr. Altaf Hussain. It can't be said that that's too minor for the court to pay any attention to it. It can't be said that it's the sort of decision which, even if irregularly taken, could readily be cured and so should not be subject to any relief. I get that phrase, readily be cured, from a case called Bentley Jones, which is in the authorities bundle at tab 2. The case starts at page 13.
Do you want us to go to that now?
It may be helpful because I won't need to go to Bentley Jones again.
Right.
Yeah. That was a case in which a plaintiff director had been removed from the defendant company's board by a resolution that was irregular, and the plaintiff applied for an injunction, and the court refused to grant relief on the ground that irregularities could all be cured and the result would be the same. And that ratio is to be found at page 641A to B. But we're not looking here with the constitutional issues in our case, the irregularities in our case. We're not looking at something where the irregularities could all be cured and the result would be the same, because to cure the irregularities, it would be necessary to restore the Rabta committee and to take guidance from Mr. Altaf Hussain. And there's absolutely, and there's no sound basis to think that if that had happened, exactly the same resolution would have been passed.
That assumes that clause 9b remained in force despite Mr. Mr. Hussain's statement, which is the subject of ground 2, which, without prejudging it, you might call a renunciation of some sort. And I think the judge found that did have some effect on clause 9b.
He did.
You haven't showed us any of that when you were going through the history. You're going to come to it at a later point.
I'm going to come to it when I address ground 2. That is ground 2. That is that the judge exaggerated the effect of the 23rd of August announcement. But the announcement itself can be seen in the same file we've been looking at. So that is S1. The announcement is at page 18 of S1.
Was it in English or in Urdu?
It was in Urdu.
Is there any dispute over the correct translation?
No, there was at one stage, but there isn't. There wasn't at trial, and there isn't now. So the version we see at page 18 is the claimant's version, and that's the version we've been working from.
I hand over complete authority, etc.
That's right. Now, the next topic I'm going to address is the pleadings. They are in the court bundle, starting at page 132. That's the particulars of claim. And I do this simply to try and illustrate what the parties thought they were going to be addressing in stage 1 of the trial. The particulars of the claim start at page 134 in the court bundle. And there's a long section which is entitled Constitutional Development, and that's at page 135, just before paragraph 6. And it avers that MQMP is governed pursuant to its constitution. That's in paragraph 6. Then it says the court will need to consider the following constitutions, and sets out a number of constitutions which the judge duly did consider. And then if you turn on to paragraphs 12 to 15, there it is explained about the emergent meeting on the 31st of August.
Does emergent mean the same as emergency?
Yes, I think it does, yes. And the amendments were approved. This is paragraph 13. And then the claimant contends, the second sentence paragraph thing, on a true construction of the 2002-2012 Constitution, the CCC was, after 23rd of August, empowered to make such amendments to the Constitution as it did. And this refers to what my Lord Justice Nugee just mentioned. Claimant avers in reliance on the relinquishment of power, the CCC was empowered to legitimately amend the Constitution, and then it approved them under Article 10. And then there's discussion of the relationship between Article 9A and Article 9B, paragraphs 14 and 15. And if you go to the middle of paragraph 15, claimant avers that the CCC of MQM was able legitimately to amend the Constitution on 31st of August and 1st of September. The defendant, having handed over complete power to the CCC Rapporteur Committee, allowed it to act in place of the first defendant and grant, with the same authority which the first defendant used to have, any act of amendment to the 2002-2012 Constitution, was and is unimpeachable. And then if you go on to paragraph 21, claimant avers that on a proper construction of the Constitution, the MQMP is the rightful MQM and or its legitimate survivor and the rightful beneficiary of the trusts. As a last sentence, defendants can't impugn the actions of the Central Coordination Committee, and all constitutional amendments had and have full effect. And all this is being said to explain why MQMP had standing now to assert beneficiary rights over the properties which are the subject of the litigation. And then after that, the particulars of breach of trust, which is really the matter for stage 2 of the trial.
Which were the paragraphs which the Master Clerk directed to be in stage 1? It's up to 23, is it?
It's as far as 23, but not including allegations about the proceeds of Brookfield Avenue, which pop into paragraph 23. But otherwise, it's paragraphs 1 to 23 of the of the particulars of claim.
So it stops at the words contends that the MQMP is the beneficiary of all the trust assets in paragraph 23, does it?
It doesn't, well, let me, excuse me. It provides, yes, the constitutional issues being all matters addressed in the particulars of claim, paragraphs 1 to 23, excluding any allegation that first and third defendants have failed to account for the proceeds of 53 Brookfield Avenues. So it's 1 to 23, and its defence paragraphs 1 to 50. And then the particulars of claim turn to breaches of trust, the trust allegations. So really stage 2, but look at what it says in paragraph 29. The claimant contends that the central issue in dispute is whether or not the MQMP or MQMA, that was their word for Mr. Hussain's MQM. MQMA is the successor beneficiary of the trust in light of the constitutional and procedural developments outlined in the particulars of the claim.
You say that what the claimant calls MQMA is the beneficiary?
The claimant, no. MQMA was a special definition which was made up for the purposes of this pleading, and it's defined at paragraph 3. It said that MQM splintered into 2 elements. That which the claimant represents will be referred to as the MQMP, and the element which the first, second, fifth, and sixth defendants represent will be coded as MQMA. So it was a definition for the purposes of this pleading, but it was one rejected by the defendants in the defence, because the defendants, their case is that they represent MQM, and MQMP is something different.
So, I'm sorry, I didn't make my question clear. Who do you say is the beneficiary of the trusts? You say it is still MQM.
It's MQM.
And that is the organisation which is run from London, is it? Or what is it?
It is the organisation that had the 2016 Constitution, April 2016 Constitution.
and what now represents it?
That's a difficult question, my lord, what now represents it. But there are people who are supporters of MQM who have never accepted membership of MQMP, and so you'd have to investigate who represented MQM.
I see.
But it's not MQMP, is your case.
It's not MQMP. That is our case. That MQMP has no interest, no title to bring this claim.
And if we just pause for a moment, looking at the way it was phrased or structured in the particular claim, the case being advanced by the claimant is that the MQM splintered into two elements, and that MQM effectively became MQMP as a result of the constitutional amendments that took place on 31st of August and 1st September 2016.
Yes, that's right. That's what they said. That was the central issue. That was how they explained that they came to be in the position to.
And it was those constitutional amendments, following on from the the events of the 21st, 22nd of August, that resulted in them effectively being MQM.
Yes. And that was the sequence of events that was rejected in the defence, to which we'll now turn, and that starts at page.
And sorry, I know this is, but as I understand it, your case is the judge did not decide those issues.
The judge did not decide those issues. No. No.
Yes.
He did not.
Yeah.
The route taken by the judge was that there were other ways he could decide that MQM was the same as MQMP, and the constitutional issues were not a defence for these defendants anyway.
Thank you. Yes.
I'm just going to take more water. Excuse me. So in the defence, the court would like to look at paragraph 7 to 9. So we'll start. This picks up on the MQMA point. That's paragraph 5. Any suggestion that MQM did not continue after August 2016 up until the present day under its existing 2015 constitution and as a separate unincorporated association MQMP founded in August 2016 is denied. If you then turn to page 8, it was this very brutal crackdown by the military authorities in August 2016, which motivated the claimant and his associations to set up MQMP as a different unincorporated association to MQM, so that they could enjoy the patronage and protection of the military authorities while masquerading as the same organisation to the outside world, presumably with the object of enjoying the privileges of an approved and registered political party, as well as attracting funds for its own purposes and uses for the benefit of officials insofar as sanctioned by the military authorities. And the point is made how it's not practically possible for MQM to successfully challenge any actions in Pakistan. Paragraph 11. There the defendants repeat the contention that MQM and MQMP are separate unincorporated associations, and the last sentence it said MQMP has simply copied substantial parts of the previous 2012 constitution in formulating the terms of its 2016 and later 2017 constitutions. That's a reference, 2016 is a reference to the constitution produced as a result of the amendments made at the end of August. And then at paragraph 14, there's points made about the terms of the 2015 constitution, how it hadn't complied, the decisions taken have not complied with the 2015 constitution. Those have been overtaken by the judge's decision that the 2015 constitution wasn't in place. But if you go to paragraph 16, there is an allegation that even if the 2002 constitution of MQM had not been superseded by its 2015 constitution, Article 9b of the 2012 constitution nevertheless necessitated guidance and ratification from the First Amendment on major issues. It wasn't sought, and further, it required, Article 10 required a 2/3 vote of the Rabita Committee, and no such vote was obtained in respect of amendments in August and September. MQM would still remain in being as a separate unincorporated association on the terms of its 2002 constitution, and MQMP would be operating as a separate and distinct unincorporated on the terms of its separate 2016-2017 constitution. And then the reply well, I don't think I really need to, the reply reasserts the claimant's position, and what is significant is that there's nowhere in these pleadings is there raised anything to do with events that happened after the August-September amendments. So the claimant was not referring to later events in order to explain why it was the correct claimant. He was the correct claimant. The claimant said there'd been legitimate amendments made in August, September, and the defendant's case was that MQMP was not the same as MQM. It was an interloper and had simply copied out chunks of the MQM constitution. And when the case was opened in front of the judge, it was accepted by the claimant that it was necessary to show a continuum between MQM and MQMP, and for that purpose, please could you look at supplemental bundle 2, 174, pages A to 174 at letters A to F. Mr. Mohammed, there between B and C on page 174, he says, the crux of this case, this is at B, really, my lord, is whether or not there's a continuum of the MQM, continuing as an undisturbed, unperturbed body to this date. With, as we say, the only thing that's happening was on or before 21st of October, September, my lord, I put October in my skeleton argument, but it should actually be September, whether after that point, as the MQM was progressing in its history, there was a departure of a group of people from that party. And then you go to E to F. This is a reference to the resignation, the alleged resignation in Mr. Altaf Hussein's letter. And the RAMTA committee, it said, between E and F, can take any decision it wants without reference to Mr. Hussain, regardless of what constitution prevails at that time. The continuum, therefore, we say, is that the MQM continues, and this is how relevant events unfold. And then go to page 181 at E. Well, my lord, in terms of issues that this court is asked to decide, it's a very narrow issue. The two narrow issues are whether or not there's a continuum, well, yes, of the old into the present. And then there are points made about the lack of records. And then in the opening for the defendant, you go to page 205. At D, what is before you for decision? These are my submissions, I think, open submissions. What is before you for decision? It's not anything to do with the political arena. The question is the claimant representative of an association which is the same or with a mere name change, or is it legal successor to MQM? And there are three reasons why the defendants contend that that answer is no. They're all to do with not comply with the constitutional requirements in August 2016. And then at the end of the case, closings, Mr. Mohammed comes back to the question of continuum. That's supplemental volume 3 at page 596. G.
Sorry, could you give me that again?
Yes, it's in supplemental 3, page 596, starting at G. The issue is whether or not, on the evidence you've heard and the submissions that have been made in the particulars in the reply to the defence and party interest, whether you're not satisfied on the balance of probabilities today that the claimant who represents the MQMP is the successor in the continuum post-August 2016 to be the MQM, and therefore to be entitled as the beneficiary to the properties of the MQM as are under the trust at the moment. That is the crux of our position. And then if you go to page 612, at E, Mr. Harmon, well, my lord, if the court decides that the amendments have not taken place, the issue then is whether the court will say that it relates back to the properties. It's whether or not the continuum. Page 612 at E.
Yes, thank you.
It's whether or not the continuum of the party. No, it's got nothing to do with the continuum. I don't know why you keep using that phrase. It's got nothing to do with the continuum. This is all on the proposition that you are the party. So the judge was indicating that he didn't like the regular references to the continuum. But that's stemmed from the fact, I will submit, that the judge took the view that the issues before him were not ones that he would have preferred to have. We submit that on the constitutional issue, our submission is, although I know the Court of Appeal is not being invited to decide the constitution issue, but our position is that the amendments have no more validity, that the amendments from August and September have no more validity than if Mr. Dr. Farouk Sattar had announced all these actions by himself, rather than purporting to act through an alleged but rigged raptor committee. Of course, MQMP certainly exists. It has a registered constitution and it participates in elections. But when the constitutions that have been lodged and the elections have been held on the basis of new constitutional rules, which are not binding on MQM, then that is the action of a new and separate association, however much that separate association might like to claim the mantle of MQM. Now, I'm going to take you to the judgment, but just give a brief overview.
Can I just ask a question, the answer to which may be obvious, but I think it's worth just highlighting? It was implicit in my Lord Justice Nugee's question to you earlier, but the reason why all of this matters is because we are trying to identify the beneficiaries of the trusts. There's no dispute that there are trusts. The question is, who's the beneficiaries? Because that affects the question of who has standing to bring the claim.
Yes.
Yeah.
Yes. For the purposes of this action, the defendant's position is that we can prove that MQMP is not the correct beneficiary.
You say you can prove that. Strictly speaking, I think you say it's not for us to prove anything. It's for them to prove that they have standing qua beneficiary.
Yes, yes, I'm grateful. Thank you. Yes. So we take a point about their standing as beneficiary, and if we're right in that point, then they are not the correct claim. They're not the right party to be represented by this claimant, and the claim fails. It doesn't for a moment decide who the beneficiaries of MQM are. It wouldn't prevent other people coming along and saying, well, actually, we are the correct beneficiaries of MQM. We're not bound by this any discussion. So whether the claimant wins or loses, it doesn't bind other people who may say that they're the beneficiaries. And the way that could have been got around is if the claimant had sought to join representatives of MQM.
If your position is, if you're right on the constitutional issues, it follows that the claimant is not MQM. Therefore, the claim fails without having to decide whether there have been any breaches of trust or any liability to anyone, because that simply doesn't arise unless the claimant can establish that MQMP is the beneficiary.
Yes,
And
yes.
in order to, I mean, the judges write, even on your case, to this extent, that what he calls the identity issue, whether MQMP is MQM, is what has to be decided. You say, where you take issue with him is he says, I can decide that without looking at the constitutional questions, and you say, no, you can't decide it unless you decide the constitutional questions. That's it, really, isn't it?
Yes, yes, and the judge, with respect, he took the view that he could unpack the identity issue from the constitutional issues, and this is clear from very early on in his judgment.
Yes.
And he even thought that that he could reach a conclusion under which the constitutional issues didn't arise.
Not only didn't arise, but weren't matters for the trustees in any event.
Yes, well, then he went on to say that too. Exactly. So
You say that they aren't two separate issues; they are the same issue.
that was that.
That's your
yes,
case.
Yes, and it was the judge himself who came up with the phrase identity issue, and of course the question of who is MQMP, that was at the heart of the action. So in that sense, there was an identity issue, but that was all to be determined by the constitutional issues. That is how the parties had approached it, and the judge came up with a new method of approaching it. So this will, it's probably best if I address the terms of the judgment in detail as we look at the grounds of appeal. But they're essentially something like nine sections that the judgment can be divided into. The first runs from paragraphs 1 to 31, which are the judge's introductory remarks, and it is here that he first makes it clear that he sees the identity issue as being different from the constitutional issue. And since and really that is what we get from paragraph 16 of the judgment. Both sides have concentrated in detail upon the following issues. Well, I think that's rather complimentary to both sides. I don't think both sides had any idea they were concentrating on the so-called identity issue that we see in number 1. And then you go to, that's the identity issue. And then number 2, if MQM is now known as MQMP, whether those now in control are acting unconstitutionally.
You say that's backwards. You can't decide that until you've decided the constitutional issue.
Absolutely, it's not it's I'm not sure. Is there something worse than backwards? It's it is assuming that MQM is MQMP, and then saying, well, there's some constitutional issue that has to be decided, and that is putting the constitutional issue as a decided assumption right at the start. So it's
to this extent, the judge is right. Once you reach the conclusion that MQMP is MQM, then it's no defence to a breach of trust whether people running MQMP have been running it properly or not. So I can see why he says what he says there, but you say that the only way to decide if MQMP is MQM is to look at what happened in August and September 2016 and decide if it was constitutional.
Yes, but the judge thought that you could get to the conclusion that MQM was MQMP, and then go on to look at the Constitution.
Yes.
And so it's here that we see, first of all, the identity issue being raised separate from the constitutional issue. And we see in these paragraphs, leading up to paragraph 31, the judge's concerns that this is not this is not a defence that the trustees should be raising at all. Really,
Sorry, where's that? 18.
It begins, yes, it begins at 18, but the judge goes into more detail leading up to paragraph 31. And you can see at the start of paragraph 26, again, the line of thinking taken by the judge that does not, with respect, represent what the defendants were trying to say. This is the second sentence in paragraph 26. If MQMP is a separate association and not a beneficiary, the issue will not arise, he says. So there's no constitutional issue if MQMP is a separate association. Therefore, the active defendant's case for this issue proceeds on the basis that MQMP is MQM.
You say that's a complete misunderstanding.
And then you can see the conclusion that the judge reaches in paragraph 30, bottom of paragraph 30. The problem for this case, however, is that the MQM constitutional issue, at least, is not on the face of it a defence relevant to the alleged misconduct of the active defendants as trustees. I'm sorry, no, I've taken that out of context. That's not fair to the judge. I'll come back to that. That's not. Right. So just again an overview of the judgment. That's section 1. Section 2 is a long section which deals with the question of whether the 2015 constitution was adopted, and it runs to paragraph 107. And he concludes at the bottom of paragraph 107, it can be concluded on the balance of probability that it was not. That is, that the 2015 constitution did not replace the earlier constitution. MQM's constitution was the April 2016 constitution at this time. That's a conclusion that, with regret, but we go along with it. Then at paragraphs 108 through to 117, these are the paragraphs that deal with what might be called the apology and stepping back matters, paragraphs 108 through to 117. And that is the subject of ground 2 of our appeal. And then at paragraphs 118 through to 137, he deals with the events of the passing of the resolution in late August, and he touches in this section at paragraphs 133 to 134. He brings a conclusion as to the true construction of Article 9A. So that's how do you apply the measure 2/3 of the committee. That's where his conclusion is to be found in there. And that is our ground 3 in the appeal. At paragraphs 138 through to 143, he addresses the problems that there are with counting up votes under the constitutional issue. And later he decides he does not decide it. But anyway, he addresses there the problem of counting up votes. At 144 to 170, he addresses at some length events which took place after the resolution. And he plainly, we submit, relies on these events in forming his conclusion that MQM is the same as MQMP. And then at paragraph 171, he says the findings of fact resolve the MQM identity issue without needing to trouble further with the distinction between the active defendants' position as trustees and their personal interests. The finding of fact being that MQMP is MQM. But nevertheless, he goes on after that to consider at paragraphs 172 through to 174, and he reaches a conclusion that the constitutional issue is not a defence to the claim, and that's ground 1B of our appeal. And then at paragraphs 175 through to 177, he says that in any event, the constitutional issue is not in a satisfactory state. And then he winds up with his conclusions. I ought to just look at 181. In all these circumstances, the parties were given the opportunity before the hand-down of this judgment to identify any extant reason for a further hearing. They've agreed that it's unnecessary as a result of the decision that MQMP is MQM, but subject on the part of the active defendants to the reservation of their position should there be an appeal of that decision, and it is successful. So I put that, cite that paragraph to draw attention that we did reserve our position in the event that we met with success on appeal, but it is said by the claimant on this appeal, no, we had our chance to ask for a further hearing and we should have taken it then. And then the decisions handily listed out at page 104, 105, A, that's ground 1A of our appeal. B and C, there's no challenge to B and C. D, that's ground 2 of our appeal. E is ground, insofar as it features, that's ground 3 of our appeal, because the judge did reach a conclusion of construction on the 2016 Constitution. F, that's a finding which is subject to our ground 1B of the appeal. And then he says, even if it was a defence, the decisions of the 31st of August have been superseded by events. That's ground 1A of our appeal. And then other matters are raised by the judge in H and I, but I think if they are not relevant if we are successful in our appeals on the other grounds. So ground 1, if I may, I'll now address ground 1A of the appeal. That is, the identity issue could not be separated from the constitutional issue. We've already looked at paragraph 16.2, which is at page 68 of this file. This is how the judge sought to separate the identity issue and the constitutional issue. But as a general observation in his judgment, if he was not going to decide identity on the basis, the pleaded basis, which was the validity or otherwise of the August-September amendments, he didn't explain in any clear passage in his judgment what principles he was going to follow instead. And since we are dealing with unincorporated associations, and the binding document for the members of that unincorporated association is the contract, it was an omission, we submit, for the judge to think that he could draw conclusions about the identity of MQMP without drawing to a conclusion the constitutional issues. We can detect themes in his judgment that he clearly thought were important, and I've addressed these in my skeleton argument at paragraphs 24 through to 34. The first feature is the statements of subjective intent on which the judge relied to support his conclusion that there was no new association being formed. And I'll take you to the relevant paragraphs in the judgment. If you start at paragraph 118 on page 90,
Sorry, page?
Page 90, paragraph 118 of the judgment. He cites some of Dr. Sattar's evidence, and then his summary is, while this raises the issue whether this was constitutional, it is not evidence of an intention to form a new party. It is evidence of an intention to continue MQM without Mr. Altaf Hussain. Then paragraph 119, a contemporaneous note of the press conference. We looked at that. That's what is at paragraph 20, at page 20. This identifies an intention to continue operating MQM. The suggestions, he says at paragraph 120, are consistent with MQM continuing and inconsistent with a new association being formed. Now, that is pushing things a bit, I submit, because the suggestions include excluding non-Pakistan members of the Rabta Committee and co-opting old veterans as members of the Rabta Committee. That's a pretty fundamental step to take. Why that is inconsistent with a new association being formed is open to challenge, I submit. And then go to paragraph 122. Oh, I'm sorry, no, in fact, I think 122 is addressing the same document as 119. But what is not addressed by the judge is the constitutionality of what was being proposed at the press conference at the meeting on the 24th of August, the rooftop meeting on the 24th of August. And he gets to the amendments themselves, paragraph 126. This is, he attaches weight to the fact that these are all using MQM documents. And he concludes at paragraph 127, these are the amendments challenged as void. However, that does not alter the fact that the intention of those voting was to amend MQM's April 2016 constitution. You needn't worry about the next sentence.
Well, it's completely remarkable reasoning, isn't it? You say, because you say what that betrays is an assumption that a mere intention to change a constitution is good enough,
Yes,
whether your constitutional change is valid or not.
yes, yes, and who is doing it is quite good enough too. It doesn't matter if it's just announced by Dr. Farooq Sattar. If you announce it with a clear intent, that's perfectly good enough to amount to a legitimate development of MQM. Now, the judge never explains exactly how he thinks these factors are relevant, but he certainly does rely on them as part of the material in reaching his conclusion that MQM is the same as MQMP. Now, there was some evidence which the judge also relied on, which is that Mr. Altaf Hussain's view was that Dr. Sattar was hijacking the true MQM, not forming a new party. And we see that at pages, paragraphs 236 to 239 of the judgment. And he says there was an inconsistency in the evidence. It's quite difficult to follow. But the conclusion of the judge at 237, it is to be noted that there is an inherent factual inconsistency between the allegation that a new party was formed and the allegation that Dr. Sattar changed MQM's constitution and excluded Mr. Altaf Hussain from MQM at the request of the Army, ISI, and all government. Well, it's not much of an inconsistency if it is Mr. Hussein's case that all this is being done illegitimately, completely unlawfully, which is what he was saying.
Well, you say the word should be sought to change.
Yes.
So far as, but how does that tie in with 115? I wasn't quite sure. Sorry, 115 in the substantive part of the judgment.
Yes, thank you. Well, I think that reference at 115 is probably to what the judge goes on to say at 238. He explained the position differently. He accepted that it was the motions asserting treason against himself from the National Assembly of Pakistan and the Provincial Assembly of Sindh on the 21st of September which gave rise to the new party. He accepted that prior to that, Dr. Sattar had acted for and in relation to MQM. He accepted that he'd not objected to Dr. Sattar's actions before those motions because he was ensured by Dr. Sattar that all would return to normal as long as he remained quiet. That he thought he would allow the events of 22nd August to blow over. he now stated that MQMP was formed as a new party after the Assembly of Pakistan's resolution to prosecute him for treason. And then the judge thinks that this is a good example of the problems of memory.
But in 115, he said that Mr. Hussain's evidence was not that MQMP was established as a new political party. But then at the end of 238, MQMP was formed as a new party. So I wasn't. Is it a timing issue?
Yeah, I think it's true. In his witness statement, Mr. Hussain had said that MQMP was a new party, and yet under cross-examination, it was said that he had not said it was a new party until later in
So it's
September.
timing, yeah.
So it's a timing issue. So he was changing his mind as to whether it was a new party or not. But nevertheless,
Or when it was a new party?
yes,
Yeah.
Mr. Hussain was not accepting that anything was being done lawfully. He was keeping quiet and waiting to see until things whether things sorted themselves out. But it wasn't an acceptance that what Dr. Sattar had done was legitimate.
Judge seems to have thought that it was only a new party if you set out to, expressly set out to say, I'm founding a new party. And because Dr. Sattar didn't do that, what he did is he took the existing party and tried and amend it, what your client called hijacked it. Therefore, it wasn't a new party. It was an attempt to change the old party. But your case is, if the hijacking is illegal, it is a new party in law, whatever you say about it.
Yes, yes. And particularly in circumstances where you then go and lodge resolutions and constitutions and you have elections on the basis of rules that are not binding on MQM, that is a new party. It exists as a party. It is an unincorporated association, but it's not the same as MQM. And the judge's attention given to announcements made at the time were completely misplaced when he should have been focusing on how members of MQM who had been bound by the April 2016 constitution had been transformed into members of MQMP, now bound by a different constitution.
And the fact that it's a political party actually is irrelevant, because you say that the same legal approach applies to any unincorporated association.
Oh, yes.
The same is true of religious groups, golf clubs. The principle is straightforward, namely they are bound by their contract.
Yes, with the possible gloss with political associations that people are keen to claim credits and put labels on things to give comfort that maybe
They are equally keen when it's religious groups.
All right. Yes. But it's a matter of labelling, but it's not a matter of the substance of the contract. Excuse me.
And your fundamental case is that the status or standing of MQMP depended on the resolution of the constitutional issues.
Yes.
An intention, I suppose, at one level might be relevant, but is not relevant in the way the judge sought to use it.
Well, contractual intention might be relevant. How do you say that people are bound by the Constitution? How do you actually fit that in? And I'll refer you to authority later that people can become bound to new rules through acquiescence if they're given a rule book. Then that's one way in which you can create a new association.
But they're still determining the
They're still-
constitutional issue as is
Yes.
described in this case.
Yes, yes. The next category of criticism we have is that the judge proceeded on the basis that even after the August amendments, the Rabta committee continued as before, in that he frequently referred to the CCC in his judgment as if it meant the valid, true Rabta committee of MQM, whereas in fact the whole constitutional issue focused on whether this Rabta committee was a rigged and purged body with extra people put in. Those passages from the judgment are to be found at paragraph 145. It is clear the CCC continued to govern MQM on the basis that binding decisions had been made at the 31st August and 1st September meetings, and the September 2016 Constitution had been adopted as an amendment to the April 2016 Constitution. Well, it was not clear unless you assumed that the CCC was the legitimate CCC, and the constitutional issue was designed to challenge that. Paragraph 100.
That's stating a proposition without deciding it. You're just stating that they were binding decisions without having anywhere in the judgment decided that they were constitutionally binding.
Well, he's omitted to remember that you can't refer simply to the CCC without bearing in mind that there is a constitutional issue that we say undermines the CCC.
Yeah.
And then you go again to paragraph 171. This is the third line on page 100. The use of MQMP was only a change of name. MQMP's members through the CCC have adopted the 2017 Constitution.
But this is all presuming that it's valid.
Yes,
If
yes.
it ain't valid, then it doesn't follow.
Yes. And there are other quotes that I give at paragraph 28 of the skeleton.
It's all to the same effect.
Which is to the same effect.
Yeah.
And the judge took the view that if he were to decide that the August-September decisions were ineffective, then he would be deciding that all subsequent actions of MQMP were void as well. But that wouldn't follow at all, no. What followed was that MQMP was a different unincorporated association from MQM, but a perfectly valid unincorporated association. And our next category of criticism, respectful criticism towards the judge, is that he plainly placed reliance on events that had happened after the August-September resolutions. And in particular, those events were that the amendments made in August had been lodged with the Election Commission. So there was a resolution to lodge them immediately with the Election Commission. That had happened. On the 7th of October 2016, MQMP held internal elections. There were more elections at the end of October 2016. And then the new Rabta committee adopted the September 2016 Constitution on the 3rd of November 2016. And the reference there is 182G in the judgment, page 105. And then since then, the MQMP have amended their September 2016 constitution and adopted a new constitution. And that's again the same reference, and we see a piece of paper in volume S1 which shows that. That's the piece of paper we see at page 62 of volume S1. Now, nothing about events after August 2016 had been pleaded in the statements of case as being relevant. And I respectfully submit it's still not clear what relevance the judge, how the judge thought.
You say could only be relevant to ratification, but there was no case of ratification.
There was no case of ratification, and the judge didn't think in the reasons he gave that these were, that he had made any case of ratification. And that is at page 126. This is his reason for refusing the permission to appeal.
Yeah, but he doesn't explain what he was doing if it was not deciding ratification.
No, it might have been simply, well, time has passed, but it looks more than that with respect. And the two key passages to show that the judge did attribute considerable emphasis, that's paragraph 178 of the judgment, which is page 103. This comes after he's said that the constitutional issue is not in a satisfactory state. I've considered it right to draw attention to those matters for consideration if there is to be a further hearing. There is one overshadowing point. So he's looking at these events which happened after the resolution was passed and thinking these are important. And he comes again to make the same point in G on page, paragraph 182 G on page 105.
Yeah.
Where
And
he says
you say as a matter of legal analysis, that can only be a finding of ratification. What else can it be?
well, that is what I submit it is, even if the judge didn't recognise it, that is what he was doing. And had there been any case of ratification pleaded at trial, this would have opened a whole new area of inquiry on the evidence.
But it seems a bit of a bootstraps argument. The suggestion that the new RADTA committee has adopted the amendments and it's now been amended again in 2017 all depends upon showing that the RADTA committee was a constitutional committee, and if it wasn't, it can't turn itself into one by amending the constitution again.
Well, it only can if you say there's going to be some ratification, or so
Ratification
there's
has
some.
to be by the membership, or at least by the old RADTA committee.
Yes.
The membership, as I understand you, includes members outside Pakistan who never became members of
Yes.
MQM.
No, there is no question of ratification because the approval of the membership as a whole has never been sought or given, and I've shown you the objections that have been made that were made immediately. The RADTA committee, the purged RADTA committee, came up with its decision. The objections were immediately made that you can't have MQM without Mr. Altaf Hussain.
Are the other trustees, the relevant trustees, are they members of MQM on your case?
Yes, they are members of MQM.
don't at the moment see why they can't take the constitutional objection. But that's a point you're going to come to.
Well, in fact, my lord, they already have. I mean, Qasim Ali was one of the persons who gave one of those tweets. He's the sixth defendant. He was one of the Qasim Ali, and he tweeted that it was unacceptable to have MQM without Mr. Altaf Hussain. But I tried to set out at paragraph 33 of my skeleton argument all the areas that we would have wished to investigate and make submissions about had we thought that we were dealing with a case that involved ratification. And it would have started from the time of preparing the disclosure issues. Well, it would have started from insisting there should be some proper pleading about it, so we knew exactly what target we were supposed to be hitting. But there never has been any case of ratification raised, and if that's what the judge thought he was doing, that is a serious injustice, I submit, to the active defendants.
Can I just be sure on the facts? You showed us that MQMP, Dr. Sattar, was concerned to ensure that only those resident in Pakistan should be members of the CCC. Is it also the case that the ordinary members of MQMP are confined to Pakistani residents?
I think it may be a requirement they're Pakistani citizens, but not, I don't think they have to be residents. This is MQMP.
Members. Yes.
To ordinary members. I'll take instructions and find out.
In any event, your clients, who are trustees and were members of MQM, never became members of MQMP, or?
No, they did not become members of MQMP. No.
Thank you.
There is some authority which is helpful on this point, which is Abbott and the Treasury Solicitor.
Can you explain to me why we need to look at that? Because as I understand it, you say that's an authority on what you need for a valid ratification, but you only get into ratification if it's pleaded, and it's not pleaded.
Yes, and I say that it couldn't. It would have been hopeless had they tried to plead it. It would have been a hopeless cause using the tests set out in Abbott and the Treasury Solicitor.
Is that one which says all the members have to acquiesce by being given the rules and not objecting?
That's it. That's it. Yes. That's it. And nobody objecting at the time, and nobody objecting still. I mean, it seemed as if. Yeah, I think anyway. Good. If you feel you don't wish to be referred to it, I don't get anything out of it. I don't get anything further out of it except it sets.
Sorry, I wasn't trying to stop you, Mr. Slade. I was just questioning whether you really need it. That's all. But it's a matter for you, of course.
Sure. I would find it helpful to see just what is said.
Yes. Very good.
If you don't mind.
Yes. Thank you. So it's at the first tab of the authorities bundle. It starts on page 3. It was a case in which a British Legion club owned some land, and there had been a move to change the British Legion Club into a working man's club, and the purchaser of the land raised a query about title, and there was no provision under the rules of the old British Legion Club about how you could change the rules, but there had been a vote to change, and after that, a new rule book had been sent out to all members of the old club, and none had objected, and it was on that basis that this is Lord Denning's judgment, starting between D and E on page 583 of the weekly law, 153 of the weekly law report. In any event, however, he says he makes an observation which I think has not met with complete approval. It was implied that members could, on notice by a simple majority in general meeting, amend or alter the rules, but I'm not sure that that's necessarily accepted as being a correct statement of the law. But the main point is what follows. In any event, however, if at such a meeting a majority purport to amend or alter the rules, and the others take no objection to it, and instead by their conduct acquiesce in the change, then those rules become binding on all. And then he gives examples. And then at G, in this case, the new rules were sent round to all the members of the British Legion Club. If any of them wished to object, they ought to have objected then. No one did. No one has objected from that time to this. No one objects now. In those circumstances, there has quite clearly been assent by all the members to the change. Lord Justice Wynne gives a very brief judgment, and then over the page, Lord Justice Cross. At C, anyone who was sufficiently out of sympathy with the changes proposed could have taken action to prevent them carrying out, with the result that the club would either have had to go on as before, or if that was not practically possible, would have had to be wound up. But no one took any such action. Even those members who voted against the proposal acquiesced in the changes, and in my judgment it would be far too late now for anyone to challenge what was done on the ground that there was no power to vary the rules. He would be held to have accepted the changes of which he had full notice. Mr. Nugee argued that the property rights of members were affected, and therefore there would be no acquiescence. But the class of members was just the same after change as it was before, and everything went on in just the same way. So I think Mr. Nugee's argument was not accepted on that occasion. I think he had a difficult
Thank you.
I've cited in my skeleton argument from the judgment in Satyan Enterprises and Burton, which has not got any relevant facts, and I know that this court will be familiar with it because I think it's my Lord Justice Nugee who wrote the judgment, and I think
Justice Arnold was another member.
he was not a member of the court. Yes, yeah. So I won't take you to that one, but simply to say that we see our situation in the category of that identified by the Court of Appeal, that judges may sometimes think and may sometimes be right, or we don't agree with that, but their own theory better fits the facts than that of either party. But if it's wholly outside the scope of the pleaded issues, that's nothing to the point. And to decide a case on a basis that has not been explored in evidence or addressed in submissions is likely to leave at least one, if not both parties, with a profound and justified sense of unfairness. And the last authority on this matter is that of Springroom.
Well, that's very familiar authority indeed.
Yes, I've tried in my supplemental skeleton argument to suggest why we fall into the category of case where even if you think the judge was making an evaluative decision, you, as the Court of Appeal, are entitled to correct his decision because he has made fundamental inconsistencies or omitted to consider important matters.
Well,
And
you say it's a failure of logic, actually.
well, that comes into it too. I'm not sure that would apply to all the categories, but some of them it does. No, that's what I was going to submit. Oh no, I'm sorry, could I make one further point? That is that at one stage in his judgment, the judge appears to rely on what was happening on Mr. Altaf Hussain's side of the line, and this is at paragraph 153 to 158 of the judgment at page 97. And the judge has looked at various announcements made and he concludes from these that these are consistent with a new association in London. So I'm now looking at 155 and 156 and 157. And 158 of the judgment, and the judge is saying, well, there appears to be a new association in London, and I would seek to make the following 4 points about this part of the judge's judgment. First, it was no part of the pleaded issues at trial to consider what happened after the August 2016 decisions. That was not a pleaded matter. And so it was not addressed in the way that it would have been addressed had it been there on the pleadings. The second point is, what happened in the course of this alleged new association in London cannot make a difference to the unlawfulness of the resolutions passed in August. Next point, it clearly shows with these events of this alleged new association in London that this is a case where there is no room for ratification, because here you appear to have rebellion at least. Certainly objection. And the fourth point is the judge, although he was ready to accept comments, announcements by Dr. Farouk Hussain that this was not a new party, does not appear to be consistent in his approach to Mr. Altaf Hussein's comments. For instance, that at the 15th of October 2016, paragraph 156, there is nothing like MQMP or MQM London. MQM is only one, and that is the MQM whose leader is Mr. Altaf Hussain. So that was an assertion that there was one MQM, and yet the judge is using it to say this is a new association.
Okay, you're not asking us to decide, or suggesting that it was an issue in the case whether what the judge here calls the new organisation, new association, is MQM.
No,
Your case is that MQMP is not MQM,
yes,
and you stop there.
Yes.
In the sense that if you're right about that, who the true beneficiary of the trusts is, it's not an issue for these proceedings. Is that right?
yes, yes. And the judge in closing submissions, the judge asked me whether I wanted to make anything of events that had happened. And this is in supplementary 3 at page 657. And the judge said 657G. He was talking to me as I gave my closing submission. So do not take this as opening the door saying, I want you to do this. It's just clearing it away. You do not want to address the events that occurred in regard to 2016 September, such as the resolution in the Assembly and what happened after that, and rely on that. Well, in reality, what I'd say about the resolution is we know that it was that prompted Mr. Hussain to say he would no longer wait to see whether the position in Pakistan was understood. Yet this was a distinct portrayal which supporters of MQM were now seeking to bring a charge for which there was capital punishment. Yes, but what I mean, sorry, this is really not an opening the door to say, if you want to, it's not, I'm just clearing it up. You don't need to make this as any part of your submissions. No, we do not. And the reason for that is we are clear in the statements of case what our objections are, and our objections as to why this claimant has no title to sue, and that's the scope of the dispute. And then then we have an exchange about that. The judge says, of course I might, as he says, between C and D, of course I might decide they're incredibly relevant and put them all in, but that's another matter, yes. But from your perspective, you should not, I should stop there, yes, that's it. Of course, I can't say what would happen if there was some other beneficiary who turned up and said, well, this is a new analysis, here we have it. I do not know what would happen then, but from our perspective, no, the story stops after Dr. Sattar's hijacked the Raptor committee. That'd be a convenient time.
Yes, how are you doing time-wise?
This is by far the longest ground of appeals, so,
Right.
it'll be, I'll probably be another 3/4 of an hour on
So
tomorrow
that's
morning.
all right from timing point of view?
Yes, my lord.
Yes. So as you know, we're not sitting this afternoon. We're sitting again at 10:30 tomorrow. So we'll adjourn now till then.
Authorize if you're able to.